Greetings, greetings. Welcome to the open forum with the three heads of state. Um, I myself, Akil Bey, the head of state from Meru State Republic, along with Kendon Bey, the head of state for DMT, uh, along with Amir L, who will be running late. So this is an open forum. Um, we will be discussing two different topics. But everybody can pretty much ask any type of question that comes to their mind. But we're going to try and stay on topic with these two different documents. One being what we see on the screen here. Um, it's a book titled, well, on what is meant by state recognition in international law. Um, the other document is in relationship to the French and Moroccan relationship. It's just a document produced by the United Nations, so we'll get to that a little bit later. So this document is being brought up, and I'll let the Wazir introduce himself as well here in a second. But this document is being brought up because there's a lot of confusion. The more states have spoken on this several times before, but there seems to be still some confusion. Being that this is a time where a lot of the more states or people looking to develop more states are they may feel they don't have a lot of time to study due to all the events coming up. Um, so this is very necessary to be repetitive with some of this information, just in different light, right? Different aspects. So we're just going to talk about recognition, but I'll allow the Wazir Kendon to introduce himself and take the mic for a while, and then we'll go ahead and get started. How you?
Islam, Kendon Bay, Wazir Dempsey. Right before the meeting has just started, I just kind of put out there about some of the meetings that I attend and some of the statements or some of the decisions that, nationals or officials may decide to make. I feel like if they really truly understand what's taking place, why it's taking place the way it is, and really how the United States they look at this and how the United States was looking at it before any of the Moroccan states even decided to try statehood. So, and I just like the second recognition, state recognition, I guess you could say, document or article that I read. And, I just started paying attention to what they described the other states went through. Some of the things, it's a implied, hold on just a second. I guess you could say, like implied, or no, not an implied, but I guess you could say kind of like a acquiesce. You know what I mean? In that aspect, and I'll give you an example. Acquiesce. So you say if you're a new state and you decide to put a particular type of license plates from the state on your car, whereas you ride around, and law enforcement allows that. That is a form of recognition. Now, did they write you and tell you that they seen you and it was okay? No, but that's still a form of recognition. So it's certain things, like that, they may deal with you with, and it's a lot of other things that's further back that we see that we didn't even understand, but they may do. So these documents kind of give a good aspect of, what's going on with a state, how a state get recognized, and the importance of the contracting state too. That's what I learned. The high contracting state in relation, just say the DMT. I really learned the difference between that. And once we kind of read this document, hopefully I can get you to understand what I understand about that. And we'll look back at some of the perspectives that were had about, the empire coming online. why we should wait about certain things, but based on what we all say we want to accomplish, we'll see how important the high contracting party is, and should we delay, or should we move forward? But with that, I yield.
All right, so we'll go ahead and scroll down here. We'll get started. And if anybody has any questions, comments at any time, just say point of interest. So real quick, this is just a table of contents, right? So we just got the different forms of recognition. We won't go over every single thing, um, but just some of these main points pretty much be everything. Um,
Point of privilege. Hey,
yeah,
you can go back to the up there to the introduction, the first little part. Let me see. Go. Yeah, right there. Let me read that part right there, the introduction. Some definitions of international law can be found on the web as follows. The body of laws governing relations between nations. International law is the term commonly used for referring to the systems of implicit and explicit agreements that bind together nation states in adherence to recognized values and standards, different from other legal systems, in that it concerns nations rather than private citizens, right? I just want to point that out. I'm gonna continue reading, but nations rather than private citizens. So if you're trying to operate out of a trust, that will be a private citizen rather than a nation. A complex network of principles, treaties,
real
judicial.
quick point of interest. Before you take, because that's important to stand to speak on even more, because you know this information has been shared with several people in more states who will hear the officials and nationals of the more states say, you know, if you're a diplomat, and this means you're a part, if you're a Moorish diplomat, you're part of a Moroccan government, right? In which that this does not mean that operating in private means you're a diplomat. Some people ran away with that understanding somehow, some way, thinking that based off of how they set themselves up with their trust and the things that they were allowed to get away with the United States system, that somehow they're a diplomat because of how they set themselves up with that trust in the United States system, or however they set themselves up. That does not mean you're a diplomat. If you're not simply a part of a state government, a Moorish state government with three branches of government, etc., then you are not considered a diplomat of any Moorish state. Period. Um, so it's just the basics of that. We just gotta, you know, stick to the basics, right? But I yield with that.
Yeah, and I'm gonna continue reading, but I want to add that too. You made me think of something because I wrote it down earlier. Another point of this was I want like everybody to understand the personality, the proper legal personality of the person, whether the person is a state or the person is a natural person. But it's not gonna always tell you that, but what they're describing. So, and when I get through reading this, what they're describing that can take place, you have to say, okay, well, does a state do this? Does this, or a private citizen or a trust? But once you read and you understand what they're asking to take place or be done, only a state can do it. I'm going to continue. A complex network of principles, treaties, judicial decisions, customs, practice, and writings of experts that are binding on states and their mutual relations. The common point of the definitions is that international law deals with the states and state activities. Addition to the states and the states' activities, international law has a wide range of interests. A shaw indicates public international law covers relations between states and regulates the operations of many international institutions. Nevertheless, the states were the original and remain the primary actors in the international legal system. This essay considers it important case of international law recognition to make it easier to understand. First, it describes the states and the criteria of statehood. After that, it will focus on the concepts of recognition, the different ways in which it can occur, and the kinds of situations it may apply in. Finally, this paper will conclude by outlining the legal results of recognition. I yield. Okay, I continue since I started. The state says the main subjects of international law. In all legal systems, the subject of law is an entity which has enforceable rights and duties at the law. It can be a company or individual, and both are defined as legal persons. By the law, legal personality is the main clause for the entities to function, or in other words, to allege and enforce a claim. International law is constituted by states, and it is generally concerned with the activities and the transactions of states. As Warbrick says, international law has something to do with states. 50 years ago, it was generally admitted that states are the only legal persons of the international law. Now, I'm going to pause right there. Now, you see what they saying. States are the only person in international law. So, okay, I'm a Moorish American. How am I going to enforce international law when it's saying the states as the only person? So now you see how we look when we send something in saying trying to have the attributes of a state and we're not a state. But today conception is rather different. The participants can be regarded as states, international organizations, regional organizations, non-governmental organizations, public companies, private companies, and individuals. International law states that an entity which meets the international legal criteria of statehood is able to be a state. In the Article 1 of the Montevideo Convention on the Rights and Duties of States provides the criteria of the statehood. According to the convention, a state should have a permanent population, B, a defined territory, C, government, and D, capacity to enter into relations with other states. Similarly, the Attribution Commission of the European Conference on Yugoslavia, in opinion number 1, declared that the state is commonly defined as a community which consists of a territory and a population subject to an organized political authority, and that such a state is characterized by sovereignty. I'm gonna pause right there, and I'm gonna try to break it down just a little bit. The community is the people, right? And you have the territory and a population subject to an organized political authority. That population subject to organized political authority. Okay, this they perspective. Uh, and yeah, it has to come from a sovereign, has sovereignty. So like it's no way that we'll get in control or have that supreme thought power without the proper structure or some type of authority. Someone always has to be over someone. Um, and that's just how it is. But I'm just pointing it out because this is how they look at it. We can't come and reinvent the wheel. They already have a substantive law that they rule the world with. But I'm gonna continue though. A permanent population that must be some people to establish the existence of a state, but there is not a specification of a minimum number of people. And again, there is not a requirement that all of the people be nationals of the state. B,
Point of entry.
territory.
That's a part right there. Point A is is some people get confused on how many people does it take to start a state, right? Where it tells you right here, the Montevideo Convention, it doesn't have a number, right? But it says a permanent population. It says there must be some people to establish the existence of a state, but there's not a specification of a minimum number of people. Again, there's not a requirement that all of the people be national of the state. So we have a territory, a landmass of people who are seen as persons, corporations, and whatnot, right? Who say, hey, we want to be, quote unquote, we the people, right? Seen as human beings. So, in order for the state to have people, what do we need to do? We'll follow international law, right? Um, we see that the state, as an entity, being a person itself, has people within it, right? So the people are the people who choose themselves, who say, "Hey, we are going to be the ones to start a state government." What does it take to start a state government? Well, we take the very basic instructions. It takes uh, a defined territory, right? A permanent population. There's no specific number. Okay, with those basic facts, what does it take to establish a government? You got three branches. You got state constitution, et cetera, right? Well, the bare minimum of all of that, right? So there is no specific number um, it takes to start a state, but if you use common sense, along with everything, it'll tell you. So this is, some people like to argue, go back and forth. You say, hey, you need all the people in the territory to agree with you. No, you don't. Not all the people, as it says right here, not all people got to be nationals of the state. Right? When the United States of America started, it wasn't everybody on this landmass and the 13 colonies that said, hey, let's sign this document or whatnot. Right. So this is just basic, very basic logic that we can use to, get rid of the gunk, all the misinformation. With that, I yield though.
B, territory. The second qualification is territory where the permanent population live on. However, there is not a necessity of having well-established boundaries as the International Court of Justice said in the North Sea Continental Shelf case. There is no rule that the land frontiers of a state must be fully delimited and defined. The well-known example is the uncertainty of the land frontiers of Israel when it was admitted as a state. C, government. A state requires a government that functions as a political body within the law of the land, but it is not a condition precedent for recognition as an independent state. D, capacity to enter into relations with other states. The fourth and last qualification is about independency. In other words, independence is indicated by the criterion of capacity to enter into relations with other states. Oh, and I want to pause. I want to pause right there, right fast. I'm gonna keep going. Uh, enter into a relationship with other states, the political group. That's what you all are trying to do, right? You're trying to get recognized.
Right.
Okay, what are the rights and duties, the powers and immunities that attach to an entity because it is a state? Crawford case law gives a list of 5 exclusive and general legal characteristics of states. 1, states have plenary competence to perform acts in the international sphere, make treaties, and so on. 2, states are exclusively competent to respect to their internal affairs exclusively means plenary and not subject to control by other states. States are not, I'm going to pause right there, point some out too. States are exclusively competent with respect to their internal affairs exclusively means plenary and not subject to control by other states. So if you're a Moroccan state and you then became a state, Now you can't be controlled by your colony state. But if you're not a state and you just standing on your square, you still can be controlled. Because the only person that can't be controlled is who? The
The
state.
state.
3, states are not subject to international process without their consent. States are regarded in international law as equal. It is a formal, not a moral or political principle. 5, states entitled to benefit from the Lotus presumption, especially that any derogation from the previous principles must be clearly established. These are the criteria and the consequences of being a state. The next chapter will focus on to be accepted as a state. Before I start again, any questions? Yeah.
Islam, everybody.
Okay, go ahead. You have something to say? Okay, so I'm going to continue. Recognition. At the first years of the 20th century, there were nearly 50 states in the world arena. Just before the World War II, the number reached approximately 75. And in 2005, there were almost 200. Each state's creation again and with problems. But the recognition concept on the agenda of international community, recognition has become much important, especially by reasons of its results. What is meant by recognition of states? Grant defines it as a procedure whereby the governments of existing states respond to certain changes in the world community. Then it can be said that recognition is an activity of states as a legal person of international law. As mentioned above, because it is results, today recognition is a popular subject of international law. Recognition of an entity does not mean only that this entity has met the required qualifications, but also that the recognizing state will enter into relations with recognized states and let that state to enjoy usual legal consequences of recognition, such as privileges and immunities. Y'all see that language, privileges and immunities, within the domestic legal order. Therefore, it is claimed. Um, therefore, it is claimed that generally the decision of to recognize or not depends on political views. Someone needs to pause. Mute. Depends on political views rather than legal grounds. It is right. I'm gonna pause right there. Political views rather than legal grounds, right? Political, we know political deal with what? International law. And legal grounds, we know that deals with like legislation, domestic laws. And I want to point, that's another way, like I understand this information, like how I know that. So I'll just get an idea, a picture in my head of what they're talking about based on what I just described with the domestic and the international law. It is right because to enter into relations with a foreign state and permit some privileges to her is directly relevant to the state's interests. Thus, when states give a decision about recognition, of course, they will weigh the advantages against the disadvantages of this decision. Is there a duty of recognition?
Point of interest. So real quick, just want to point out, because these are just some quick statements being made by some people, right? Grant, who said, who defined recognition as a procedure whereby the governments of existing states respond to certain changes in the world, right? So this is just a definition according to one man, right? So it's just build up. So what is recognition, right? A lot of people just think it's just, oh yeah, we received your documents, right? Some people just think it's, you got to get permission from the Europeans, right? Some people just think it's session documents. But what does this mean? What is the jurisprudence of this? What is it saying? Um, so recognition, we're talking about something as we build up. I just want to call out, we're talking about something that um, is a binding obligation to basically uplift fallen humanity, uh, as we're supposed to according to the laws and the treaties. There is this is a must, right? So, um, are the Moorish states recognized at this moment by United States, or are we recognized by France or Russia? That's a question for the floor.
Not yet, or well, yeah, that's my answer. Not yet.
Why do you say that?
I mean, because like when I said not yet, like I'm not even sure why I even said not yet because we already have like Meru and what we have together already. So I guess when I say not yet, I guess I meant like more of the other states coming along and then coming into the WRC. Then that not yet could be yes, but yeah, that's just my explaining of why I say that.
Point of privilege. Okay, and it was good you said that, but I want to just give you perspective. So yeah, we indirectly getting recognized because you didn't recognize the empire already. They recognize us. So it ain't happened fully, but I'm just trying to give you the perspective why we are recognized because you already recognize the empire that recognizes us. Like that's
Because
the
of the
proper
treaties, right? Not to cut
right.
you off. Okay.
Exactly. So that's contract law. How you can, what contracts you are part of. Just trying to give you, that perspective. It's not confusing. That's how we're recognized. So that's why we do everything in the name of the empire because that's the high contracting party, the proper legal person. With that, I yield.
Yeah. And before we continue, it furthermore states that because some people have a problem with this word state, still don't understand it, right? Or even in the Act of Adversaries, which 12 other signatory powers, European powers, signed on to recognizing Article 121, for example, it says all Moorish states shall have state constitutions. So what are these Europeans recognizing? Moorish states. Simple as that, right? So we can continue with the, the remaining.
I did have one last point of interest though. We're good that you had said this is a must because it is a must. But yeah, that's all I wanted to say. Yeah.
Is there a duty of recognition? Luther Patch and Guggenheim hug the opinion that recognition is constitutive, but there is a duty to recognize. This point of view has been criticized as bearing no relation to the state practice and for its inconsistency. Brello asserts that recognition is an optional and political act, and there is no duty in this regards. Keep going. I'm gonna just say this real fast. I keep going. I want y'all to keep this perspective too. Like they're speaking from both mind frames. You got what you understand about you trying to get recognized, but they also have a de facto recognition that they had for their states. You know what I'm saying? So keep that back and forth. But when you know the parties and what they're saying this particular state or is doing, then you know which is which. But I'm gonna keep going. Recognition of states. There are mainly two theories relevant to recognition: the constitutive and the declaratorial theory. The constitutive theory asserts that states and governments do not legally exist until recognized by the international community, and the declaratorial theory adapts that states and governments gain in the international personality when they become into existence. According, according the constitutive theory, creation of a new state depends on the acceptance of present states. The new state will have the rights and duties at the time of being recognized. However, this theory has some queries, such as what will happen if some existing states recognize the new one and the other ones do not, and how could it be possible to put in force some restraints like prohibition on aggression against the unrecognized states. The dictatorial theory claims that a state will be formed free from the consent of other states just after she meets the international requirements. This, this approach is laid down in the first sentence of Article 3 of the Montevideo Convention, 1933. The political existence of the state is independent of recognition by the other states. The declaratorial theory seems to be more adequate for practice than the others. And go up a little bit. Okay. Since the recognition has a political side, in practice, the states prefer a middle way between these two doctrines. In addition, the classic qualifications to seek some basic requirements of international law for recognition. In the past, it was sufficient for a new state to fulfill the four criteria. In the 1930s, some states also look for a new state must obey some fundamental standards of the international community. As an example, for recent times in the European communities, declarations on the guidelines on the recognition of new states. In Eastern Europe and the Soviet Union, it is indicated that the community and its members adopt a common position on the process of recognition of these new states, which requires respect for the provisions of the Charter of the United Nations and commitments subscribed to in the final act of Helsinki and in the Charter of Paris, especially with regard to the rule of law, democracy, and human rights, guarantees for the rights of ethnic and national groups and minorities in accordance with the commitment subscribed to in the framework of the CSCE. Because it's written out a long document, we could try to get to most of it, but it's good. Respect for the inviolability of all frontiers, which can only be changed by peaceful means and by common agreement. Acceptance of all relevant commitments with regards to disarmament and nuclear non-proliferation, as well as the security and regional stability. Commitment to settle by agreement, including where appropriate by recourse to arbitration, all questions concerning state succession and regional disputes. The community.
So I just want to cover, just recap these last few points, and also in relation to what I said earlier about what is recognition, what does it encompass? And it's telling us right here that when it comes to recognition, we're talking about states who respect the Charter of the United Nations, right? The basics of uplifting and fall of humanity, democracy, human rights, and right, we're not talking about no demonocracy or none of that, right? And we'll honestly make another video in regards to democracy, republic, and all that stuff. But says guarantees the rights of ethnic and national groups. Then we scroll down here. It says respect for inviolability of all frontiers, which can only be changed by peaceful means and common agreement. Acceptance of all relevant commitments with regard to disarmament, right? Disarmament, that's a big thing in decolonization, right? And nuclear non-proliferation, as well as security and regional stability. Okay, so when we talk about recognition, we're talking about a state, at least two states, right? Well, in the form of recognition, I'm talking about right here, right now. Two states agreeing that when it comes to disarmaments, right, nuclear activity, what are they saying? Okay, when it comes to international law, all these treaties and conventions, especially the ones that's acceded to, are to be respected. Therefore, nobody should have problems, right? Taking each other to court, saying somebody broke something, right? So what does recognition encompass? Well, it encompasses that state having regard to disarmament right? As well as commitment to settle by agreement, including whereby appropriate by recourse to arbitration, all questions concerning state secession and regional disputes. So we have the Wazir Regional Council, right? We have questions concerning the Moroccan question, right? The question of Morocco or on Morocco, right? All these are topics that have been talked about in AMPAGs, open forum, AMPAC study sessions, several times, right? This is all encompassed right now. All that we just read is encompassed just in recognition. Okay, so what is recognition? What does that body look like? If we were to call out the pieces to it, well, what's the organs? Well, let's just say the kidneys are right. The disarmament, right? We got the nuclear activity as the foot or something, right? Then so all of this is what encompasses recognition. Okay, so just so nobody is confused, and we learn how to enforce these words we're reading and comprehending. Right. So with that, I yield.
The community and its member states will not recognize entities which are the results of aggression. At the end of the declaration, as a conclusion, it is added that the commitment to these principles opens the way to recognition by the community and its member states and to the establishment of diplomatic relations. However, it will be well advised to repeat that in practice, recognition is used to point out political approval or disapproval. Political assessments always affect the decisions. B, recognition of governments. As mentioned above, the third criteria of the statehood is an effective government. Therefore, a decision to recognize a new state generally includes the recognition of government. They might be seen as a similar concepts. However, recognition of a government is different from recognition of a state. Did you all catch that? Like a government and a state, those are two different things. Recognition of a government would be discussed where the change of the government is unconstitutional. In practice, the effective control of the new government over the territory is a preferable uh, criterion for the recognition, but it requires being settled and likely to continue. The other difference is that the recognition of a state is about its legal personality. They go that word. On the other hand, recognition of a government is relevant to the status of the administration authority. Effective control has a common use, but it is not the only approach for the recognition of governments. The Tobar doctrine handles it in a different way. According to Tobar doctrine, an unconstitutional change of the government should be recognized only when the people accept it. This was used by the United States in Central America, especially in the order to protest stability.
Real quick point of interest. Um, you notice that organizations are not being mentioned as far as the entities that could recognize somebody, right? There's many different organizations out there. There's McDonald's, there's Burger King, there's the United Nations. Not all of these organizations can just recognize it. Organizations cannot recognize anybody, right? A lot of people are waiting for the United Nations to recognize the more states. That is impossible to do. Impossible.
Point of privilege.
Yeah.
Go ahead. No, that out. And okay, we talking contract law again. I want y'all to pay attention to this. So everybody like, okay, well, we need the United Nations to recognize us. The United Nations, they can't recognize us. We already know the United Nations can't recognize a state. So but they can hear complaints, right? So if the council court of the empire, right, if they have to make a ruling has to happen. And once that ruling happens, then the United Nations, then they can enforce it. Like that's how it has to happen. So without the
Point of
empire,
interest.
are you?
This new bribe, I just had a question to get towards the actual the treaties. Like, so what I wanted to know when it comes to recognition, does am I correct when I say that basically, or am I leading on to the right information when I'm saying that the United States entered into a treaty with the Empire of Morocco, which effectively, when Morocco gave recognition to the United States of America, wouldn't that, like, considering that we are creating states within the Empire of
You went out.
Morocco?
Yeah, you're going in
Hello?
and out, kind of. Yeah, can you repeat that from the can you take it from the top?
Yeah,
What's your
my
question?
internet
Okay,
keep kicking me out. I'm sorry, but
okay,
can you
that's
hear me?
okay. Yeah, I can hear you good now.
Yeah. So my question was, if the United States of America got recognized by the Empire of Morocco, the Sultan, and I wanted to know that when we are creating these Udi Pasadatus territories within all over this continent, what I'm getting at is, if the empire is recognized by all these European powers, when indigenous, aboriginal, or when the Moor actually wakes up and they put in a Declaration of Independence, create their constitution, and they three branches of government, do that give them the same recognition under the empire that the empire has, or do they have to have to receive a separate recognition? That's what I was asking. Like,
And that's a good question.
Well,
Oh,
go
go ahead.
ahead, go ahead, President. No, go ahead, President.
That's a good question. We'll I'll answer that now just to, before we get further with this since you asked it. But that basically as of right now, no, not at this moment, because we don't have a sultan in place to say, hey, uh the Moorish states have are in proper alignment, right? The state government. Whereas as we read this document, we'll see the different stages and different types of recognition to see exactly where we're at this very moment, opposed to where we will be. So there has to be certain things set up in place to get de jure recognition. But until then, we have de facto recognition. So I say this: it's impossible um, to get the empire government running without having individual state governments first, right? It's stages, it's a process. But being that these individual state governments have to do what they must do, however that looks like, they'll only be de facto until they do exactly what they treaties say that must happen. So some people get confused and say, hey, they're not even, in de jure capacity XYZ to, recognize. But everything is still lawfully de jure, because we have to reach a certain level of advancement um, while being internationally respected, right? as independent states working to make one central or decentralized government called the United States of, well, the Morocco. So it's a process. So that's basically why we bring it up. That's one of the primary reasons why we're bringing up this document, because a lot of people have questions that relates to the WRC. Can the WRC recognize anybody? Are we recognized? And all this types of stuff. So this book explains these different lanes of recognition. All right, so
Point
I'll
of,
expound more on that as we read this document.
okay, yeah, and I'm just add to that. Okay, every Moroccan state, right? We're provisional, right? But that means that's just like in the interim, just the meantime. But what are we waiting on? We waiting on the contracting party. But in the meantime, while you're provisional government, it's like the empire. You have those powers until the empire officially comes online. So yeah, you kind of have the powers, but not as if the actual empire was online. But that's why we're provisional until the empire comes online. But with that, I yield. Uh, in 1980, the UK.
One more point of interest, please. I got one more point of interest. My question is basically, all right, since the United States of America fails to have a central government, and the Empire of Morocco, the last thing that you said, I needed to just hear. What can you clarify what you mean when you say we are the reason why we are a provisional state instead of what state will we become if the empire became online? Like, what did it go from provisional to be what?
Okay, I'm gonna give you a good example. Just look at the United States and look at the 50 states. It's the same setup. You see what I'm saying? But you have to come up under one power. There's only one initiating power. Like we have the Empire of Morocco, like the United States had to come to the empire because the empire was that initiating power. So we're gonna all just come up under the empire because in the treaties, does it say Dempsey? Does it say Meru or Ampad? It's speaking about the empire. So the empire must come to life for this to exist.
What adventures I would like to add on to that. This is Lavoy Walker Sedan L. I'm Pale. So the United States would be the federal, right? And the provincial governments would be the states, right? So we, the provincial state governments, are the provincials, right? At that level. And when the Sultan comes into play, that will create the federal, right? And the federal oversees the provincial. I yield.
Islam.
Thank
I'll
y'all,
continue.
brothers. I appreciate it.
Islam, that was
Islam.
good,
Thank
brother.
you, good brother. I'm gonna continue. In the 1980s, UK declared that it would not recognize the governments apart from states. Shaw argues that correctly. The reason of this declaration was the perception that recognition meant approval and was often embarrassing for instances in cases of regimes violating human rights. Right, and I'm gonna point that out right there, so I'm gonna keep going. But y'all see, like human rights, just like the nature of a state. You know what I mean? Because you have these privileges and immunities, and you can either do the right thing or the wrong thing. This political change to not recognize governments officially was followed by the other countries after a short time. De facto and de jure recognition. A curse argues that the distinction between de
Real
facto
quick point
and
of
de jure.
entry. Before we continue with that, I just want to spend a little bit more time on what was just said. Um, it goes to say that the reason for this declaration mentioned, um, it says this declaration was the perception that recognition meant approval, and was often embarrassing, for instance, in case of regimes. So when we talk about regimes violating human rights. So what's our situation? Well, we're dealing with colonizers, United States of America, who've already recognized other states, including the Moorish states. So how would this be embarrassing? Well, it's embarrassing because people who go around pointing the finger gonna get the finger pointed back and saying, "Hey, you yourself hasn't done the main duty, which why we're here today, which is decolonization." To my United Nations, right? So, uh, uh, approval, the approval aspect, what is it's not necessarily approval to be who you are, because you a state can be a state in any state or in any condition, but it's up to other states to say, hey, if we recognize you, that means we want to do business with you. We have no problem. But regardless if that state wants to recognize you or not, that state can be on an island.
Can somebody mute?
So a lot of people gotta get muted. Please keep yourself on mute, please.
Thank you.
So it's a lot of people, a lot of states that want to be recognized, right? Some states might not get recognized, but still be states or striving to be, a part of some other centralized government or something like that. So when we talk about approval in what way? Approval to be who you say you are? No, because you are who you say you are. That's fine. But your harmonization or ability to work with other states and shake hands with other states, right? Make treaties with other states. It depends on the other states and if they want to recognize you or not. So when we say approval, it's not in the form of, hey, you need approval to say you are who you say you are. Yeah, you might get past that point. You might get past, hey, we created a state. But have you gotten past the point to where the other states, such as the surrounding more states, do they want to recognize you? Right. So I just wanted to call that out.
Skate argues that a distinction between de facto and de jure recognition is one of the most confused circumstances of recognition. And at first hand, he objects to the expression de facto and de jure recognition. According to him, they are technically incorrect, since the word de jure or the de facto describes the government, not the act of recognition. Indeed, the subject is about the legal status of the government. Similarly, art gives a definition of de facto and de jure recognition by relying on the legal status of the government. Recognition de jure means that the entity fully satisfies the applicable legal criteria. Recognition de facto is only of the current position of the entity, and it is therefore usually provisional. And I got that what I just explained to you all earlier from here. So right there you see the de facto, right, which is us, right? We're the provisional. It's a fact, right? That we're here, we in existence, but the de jure is the empire, right? The de jure is the legal status. So and I learned that right here, but I'm gonna keep going. The jure recognition is, of course, stronger, while de facto recognition is more tentative and more connected with effective control of the recognized state over its territory, as when the United Kingdom recognized the Soviet de facto in 1921, but de jure only in 1924. The
Point of interest.
assessment or
And just to build on top of what the Wazir was talking about with de jure and de facto, right now, our current situation, this very moment, the WRC, what status are we in? We're in de facto status as far as recognition. Why? Because the instructions that we have to do, according to our treaties, has specific verbiage with specific ranks that we have to meet, right? Tasks. It says this is who recognized. This person is not in their office. If this government is not up, then is recognition possible? No. But what is possible? De facto recognition, in which that's what a lot of people have been seeing. That's all have people have been seeing thus far, right? More states recognizing each other, saying this is what we're doing for the current, right? For right now, right? Um, but until we get into the jure status, then things will be different. So when people see groups, political groups forming, dissolve, this is because we're in a de facto or temporary or the current status, which is not de jure, because remember, recognition is irrevocable, but we'll also get into other forms of recognition, which you'll come to find out how this is exercised. So I just want to call that out.
Right. And I'm gonna continue and I want to point out that little part. Recognition. Okay, I'll keep going. Don't worry about it. No, just saying recognition de jure means that the entity fully satisfies the applicable legal criteria. So if the Moroccan states are de facto and the empire is de jure, my question to everybody, have the de factos, have we met the applicable legal criteria yet? To get what we, look around and what we think of in our mind of decolonization. We haven't.
No.
I'm gonna continue. The jure recognition is, of course, stronger, while de facto recognition is more. Oh, I'm at the assessment. The assessment or the definitions of both concepts can be changed in different situations, but it is the fact that everything is relevant to the intention of the government concerned in the general context of fact and law. De facto recognition can be thought as an attitude of wait and see, since it includes ambiguity. This method gives the recognizing state the opportunity of acting in accordance with the political facts and its interests. Premature recognition. And this, I learned this, and I want everybody to pay attention to this premature recognition. Like I said, they've been recognized as states. So you see premature recognition, but we complaining about them not doing certain things. But as we keep reading, you're gonna, understand why they have these certain things. Since it is a political decision of states, in some circumstances, the recognition occurs before the criteria of statehood have been fulfilled by the new state. In such cases, the problem is to determine the premature recognition is an intervention in the internal.
Well, I'll wait till you finish that.
Internal affairs of another state, or is admissible recognition of a new state that has emerged or is emerging as a result of secession. Recognition of Bosnia, Herzegovina, and Carter Quartal were the well-known examples of
Croatia.
Croatia
Yes.
were the well-known examples of premature recognition in the near past, as both states had not an effective control on their whole parts or of territories at the time being recognized.
All right, point of interest. So just to slightly backtrack, we talking about premature recognition. Really, this last paragraph right here. It says that this method gives the recognizing state the opportunity of acting in accordance with the political facts in its interests. This is where I want to start right here. It says de facto recognition can be thought as an attitude of wait and see, since it includes ambiguity. So this wait and see, we see that several political groups forming decided to dissolve. Some were said to be recognized through our de facto status, right? It was the WRC, because it's only de jure once the Sultan does it. So we played a wait and see to see if, right, this period is a wait and see to see if these states are states that we want to actually recognize. Because remember, it's irrevocable, right? So that's, just to clarify if this is an actual international process or not, right? It is. Just because we see the word de facto doesn't mean it's less lawful or anything like that. It's just all about dominion, right? Value in international law. It doesn't mean it's less lawful. And also that
If you need, I can read if you would like.
Okay. Yeah, you can go ahead. Thank you, Noah.
yeah, I believe I forgot what point that I was gonna mention. But so I yield with that.
E, implied recognition. Recognition is about intention and may be expressed or implied. To understand how a state may recognize another state by implications, it is necessary to look into some certain circumstances. Lauderpatch states that the establishment of diplomatic relations and may be to grant the equator or signing a bilateral treaty includes extensive relations between the two states justify the implications. A congratulation message to a new state for obtaining sovereignty will bear recognition of that state, but unofficial contact do not have the same results, just like the informal relations established between United States and Communist China in the 1960s and early 1970s. It does not mean recognition when two states both signed a multilateral treaty such as United Nations Charter. Israel and many Arab countries are UN members at the present, but it does not change Arab non-recognition of the Israel state. On the other hand, when a state affirms the membership in the UN of an entity, needless to say, the recognition occurs. As an example, United Kingdom recognized the former Yugoslav Republic of Macedonia by supporting its membership in the UN. In practice, the implied recognition is not preferred since the states want to have their control of recognition, and in general, they use a formal way for it. Conditional recognition. Conditional recognition means that to recognize an entity as a state only when it fulfills some conditions. It was first seen in the Berlin Congress of 1878. Great Britain, France, Italy, and Germany marked the recognition of Bulgaria, Serbia, Romania, Montenegro, with the condition that these countries would not impose any religious disabilities on any of their subjects.
All right, so real quick point of interest. See, so far we have different forms of recognition or different phases of recognition. And in this one, we can see the conditional recognition is applicable as such when a state fulfills some conditions, right? So we learned earlier what a state actually is, but what are some conditions? Because a lot of people say, hey, they recognize us and they part of the Moorish Science Temple of America saying that, right? So what we gonna get more specific as it relates to recognition and what states are looking for. Somebody came in loud.
That's why I did
Okay, I gotta mute you. So we'll continue, and I'll yield with that.
It may cause some political problems, but the non-observance of the conditions would not invalidate the recognition. Since the law does not attach value to any condition unless it depend upon agreements made by the particular parties.
Point of interest. So right there, again, let's just take from the top right here. It says it may cause some political problems, but the non-observance of the condition, right? What is the United States doing? Acting like they don't see us, knowing we on their minds when they go to sleep. But it says but the non-observance of the condition would not invalidate the recognition, since the law does not attach value to any condition unless it depend upon agreements made by the particular parties. So what agreements have we made with the United States? We got several treaties, give several different instructions pertaining to several different categories, right? Recognition not being one of the categories that it speaks on, but is already with the understanding with them signing the treaties with these other states, having these certain obligations between the two as far as protections and whatnot, doing business and whatnot, is saying that you obviously trust this state enough to do business and all that stuff, which is what recognition is all about. So I just want to call that out. I just want to take it, a little bit slower so we can, just really settle in on what this recognition is. Because a lot of people just seem to get caught up in, hey, United States is not responding, or hey, United Nations is not responding. Not fully studying what are the requirements, the instructions, the guidelines for the United Nations itself, as far as working with recognition in any way. What is the requirements, the guidelines, instructions for any states, especially the United States, right? Knowing that one is an organization and one is a state. So, I just wanted to settle in on this, because when we talk, another thing this leads into is security. More has come into this thinking that, more states will provide the utmost top-notch security of the world, Craig. But that's not the case. We don't have the enforcement at this moment. We're fighting through decolonization, which means that the resources, enforcement, the military, the currency, etc., that we're supposed to have will come. It's not here yet, especially since we haven't taken anybody to court. So Moors basically want to click their heels 3 times and end up at the finish line. They don't want to go through anything, which means that what we really are seeking, we got to work for. Faith without works is dead, right? So there are specific instructions in the treaties. There's specific instructions in France versus United States of America. There's only through consular court, and by that way and that way only, which means somebody has to catch a case. The state has to catch a case. And by that way and that way only is Moroccan law enforceable. Why is that said? Well, because is writing the state law just going to do it? No. It's just some policy that, is that going to do it? No, it's going to be by the most enforceable ways, which is by consular court to start off with, right? Then we go to the ICJ, and we go from there, right? But one thing that we cannot do is expect something that you have yet to work for. That's what's causing a lot of these dissolutions. That's what's causing a lot of misunderstandings. People are coming in, they say, yeah, this international law makes sense, but their expectation, their anticipation, being anxious can seem to override that sometimes. So we got to understand that this is chess, right? This is a game of wisdom. We gotta be wise in our actions, right? But don't come in just expecting a checkered board game, tit for tat, just because you sent this one document in that, full fledged, everything's coming right back to you, that next day or within 7 days or something. That's not how it works. So I just wanted to share that point of interest.
Point of privilege, right quick. I just want to throw this in to give y'all this perspective. I'm gonna read that again and show you what I kind of spoke about earlier. But I'm gonna show you standing on your square. It say it may cause some political problems, but the non-observance of the conditions would not invalidate the recognition, since the law does not attach value to any condition unless it depends upon agreements made by a particular party. So right there, this picture I'm saying, standing on your square would be knowing that the particular party that's a part of that agreement that depends upon the protections that I got. I know that the state is a part of these, and I get my protections from the state. So even with the non-observance, it doesn't invalidate the protections that I have from the state, which is that particular party, part of the agreement. So I'm gonna stand on my square. That's standing on your square, not sending a in or anything, right? I yield.
G, collective recognition. In 1971, the International Law Commission stated that collective recognition means that states act collectively during the process of receiving information of the situation, evaluating that information and reaching a decision and communicating that decision. This may be seen as a result of increased cooperation between the states. The idea of act collectively has been a subject of a debate since the foundation of the League of Nations and the establishment of the United Nations. However, the states prefer to keep the control of recognition in their authorized bodies. As Shaw stated, the most that could be said is that membership of the United Nations constitutes powerful evidence of statehood. H, withdrawal of recognition. Sometimes it is possible to withdraw a granted recognition, especially it is easier for the de facto recognition, since the position is different with the de facto recognition, which includes an ambiguity for the future of the entity. Just a moment. If the government of the entity loses the effective control on its territory, there will be no ground for recognition, and it may be taken back. On the other hand, de jure recognition is more difficult to withdraw because, as mentioned above, it is stronger than de facto recognition. De jure recognition may be the case only if the state is annexed or conquered by another state.
Point of interest. All right, so for those who been with us to experience these unfortunate events these past few weeks, some may see as unfortunate, some may not, right? As far as these political groups forming, dissolving, this is exactly what we're talking about, right? As far as withdrawal of recognition, right? So, if one state or political group forming decides to no longer work with the WRC, okay, fine, so be it, right? Um, um, so yeah, I yield with that.
Three, non-recognition. The doctrine of non-recognition, also known as the Stimson doctrine of non-recognition, means to not grant recognition to the new entities or the some factual positions which are the result of any illegal actions, such as using force. It supported the principle that legal rights cannot obtain from a legal situation. Ex injura zos non auteur. The doctrine was brought forward by the United States Secretary of State, Mr. Stimson, in 1932, relevant to the Japanese occupation of Manchuria. It was accepted by a resolution of the Assembly of the League of Nations. In the resolution, it is stated that, considering that the principles governing international relations and the peaceful settlement of dispute between members of the League above referred to are in full harmony with the Pact of Paris, which is one of the cornerstones of the peace organization of the world, and under Article 2, of which the high contracting parties agree that the settlement or solution of all disputes or conflicts of whatever nature and whatever origin they may be, which may arise among them, shall never be sought except by pacific means, proclaims the binding nature of the principles and provisions referred to above, and declares that it is incumbent upon the members of the League of Nations not to recognize any situation, treaty, or agreement which may be brought about by means contrary to the covenant of the League of Nations or to the Pact of Paris. However, this intention did not reflect to the practice until the Second World War, the Italian occupation of the Empire of Ethiopia, and the German takeover of Czechoslovakia. Thank you. Were recognized de facto over the years by Western powers. After 1945, it was again discussed and took place in some international instruments, such as UN Charter, Article 2, Section 4. The draft Declaration on the Rights and Duties of States and Security Council Resolution 242, 1967, on the solution to the Middle East conflict. Especially draft Declaration on the Rights and Duties of States indicated that every state has the duty to refrain from recognizing any territorial acquisition by another state where achieved by means of the threat or use of force or in any other manner inconsistent with international law and order. In this context, in 1990, the Security Council adopted Resolution 662, which characterized the Iraqi annexation of Kuwait, null and void, and called on all states and institutions not to recognize the annexation. 4, legal consequences of recognition. Recognition is a unilateral act of a state and one that it has international legal consequences. For instance, where states grant recognition to an entity, it accepts that they will have relations subject to international law on basis of state.
Point of interest. So this is exactly what I was saying earlier, where it says recognition is a unilateral act of a state. So this is not talking about getting approval of somebody else. When it's a unilateral act, you recognize yourself. That's where it starts. But that's not the full process. Because if everybody just walk around recognizing themselves and think that's all it takes, then where is the cooperation amongst each other to say, oh, this is the true and jure state for this territory and not these people, right? We have to have a due process of all these acts. So it's almost two sides of this. It's a unilateral act. It's pretty much like this. Establishing a state is first creating the state first and foremost, right? Um, and then but that's not all it takes to establish a state. You actually have to go through the last process of creating a state, which is recognition from other states. Because if it's kind of like saying, well, if you establish a body, right? If you just now getting on Earth, what's that movie called? Uh, uh, I forgot it. Never mind. It's something about a man coming to Earth or whatever. But if you got a body on Earth now, and you can't use anything about it, you can't see, you can't hear, you can't walk, you can't use common sense, you can't understand. What is the point? You're just gonna wither away. So recognition is it starts off as a unilateral act, but as a state, you have to follow through with several other acts to fully become a state, which is recognition from other states. Right. So it's not approval from any other state. You recognize yourself. But to fully go through the due process, you need to be recognized by other states. Right.
Important, I just want to add to that. And instead of just looking at it as just recognition, you can look at it as now you're getting in diplomatic relations, right? Now you're getting diplomatic relations at other states. So when you're doing that, that's when you're gonna get recognized. So not just the concept, but I'm waiting for y'all to recognize me. I'm just trying to get in diplomatic relations with other states. With that, I yield.
In practice, like claimed by declaratory theory, the political existence of a state is not bound to the recognition of other states. Therefore, an unrecognized state has to comply with the international law rules. It means that when the states sign an international agreement, which is signed by a state they have not recognized, they will have the right to ask from the state to fulfill the responsibilities grow out of the agreement. After recognition, the recognizing states with respect to the rights of the new state, which indicate in the International Law Commission Draft Declaration on Rights and Duties of States, 1949, such as right to independence and hence to exercise freely, right to exercise jurisdiction over its territory and over all persons, right to equality in law with every other state, right of individual or collective self-defense against armed attack.
Point of privilege. I just want to point this out too. We're talking about legal personality, right? So look, it say right there, rights to independence and hence to exercise freely, right? To exercise jurisdiction over its territory. But you see how it don't names nothing. It just says its territory and over persons. So what legal person or entity has the personality to do that? And
States.
exactly. Are you?
The participation in the international process is not the only result of recognition. At the same time, the recognized state will be able to enjoy usual legal consequences of recognition, such as privileges and immunities within the domestic legal order. As an example, police list some privileges and immunities within the municipal law of United Kingdoms as follows. Only a recognized state or government has locus standi in the UK courts. Only a recognized state or government or its agents may plead immunity from suit. It cannot be sued without consent. Only the legislative, executive, and judicial acts of a recognized state or government will be given legal effect within the United Kingdom. Shaw adds one more. It will be entitled to possession in the recognizing state of property belonging to its predecessor. 5. Conclusion. Recognition is one of the most difficult and complicated topics in international law. It is complicated because it involves important political results and legal effects, both in international and municipal law. Political assessments always affect the recognition decision. Where the states give a decision about recognition, of course they will weigh the advantages against the disadvantages of this decision. If it is looked into, the some cases relevant to recognition in international law, I think it can be understood clearly. To grant recognition completely depends on political consideration. In my point of view, recognition for a state means merely to decide that, whether it is suitable for her needs or not. There are basically two theories to explicate recognition: the constitutive and the declaratory theory. The constitutive theory asserts that states and governments do not legally exist until recognized by the international community, and the declaratory theory adopts that. States and governments gain in the international personality when they come into existence. I think the declaratory theory is more comfortable to reason and parallel to the practice of international law, and it is supported by the Montevideo Convention on Rights and Duties of States. However, I think it is very difficult to lay down a regulation on state activities since they are not stable. They may change time to time. Rules concerning recognition have the same character. Every case should be assessed in itself. International
States
law is
recognized.
made.
Real quick point of interest.
Go ahead.
So question to the floor: are the Moroccan states recognized?
Yes.
Oh man, sorry about that. So yeah, correct. So do all of us, do all of um the de facto status, right, with the WRC going through its various state of advancement, right, being the temporary and current face of Morocco. Um, so in comparison with the de jure and de facto, right, we still have the more states being recognized by the European states, which does what? Which tells us their interest. It tells us their perspective on disarmament, right, etc. So I yield with that.
International law is made by states and again, breached by states. There is always an exception of rules in international law. The important thing is to find a legal cover, and nowadays, it does not seem to be so difficult. I think in the past, states were most honest. It was easy to understand what they really intended to do, but today the situation is different. An explanation or a behavior can be understood only after seeing the results. And it is called policy, which the decision of recognition rely on.
All right, so that's the
Yeah,
end of
yeah, it
that's
is.
the end
And
of
I just want to
go ahead.
go ahead. No, I just wanted to say I had posted early. We was going to discuss the sovereign. So I just want to say the empire is the sovereign. That's the sovereign. So everybody saying I'm a sovereign citizen and I'm sovereign. No, the state is sovereign, not no one else. With that, I yield.
Um,
Point of
so
interest.
yeah,
Hear me?
you kind of breaking up, but yeah, we can hear you though for the most part.
Um, well, so from what I'm getting at, learning from what y'all saying is I, I was my de facto in nature, according to international law, but de jure according to um the United Nations Charter and the provisions within the charter, according to states and according to the Montevallo Convention, we would actually be considered de jure, and that's why the are you saying that's why they're actually recognizing the states because the contracts that they have to recognize in the United States of America um is actually have a it ceased to have a central government. So since they have ceased to have a de jure central government, we have no central government as well. We're both in two de facto statuses and trying to get back right and with each other and treaty wise, basically trying to get back into relations or proper standing in international law. I don't know if I may ask.
Yeah, so you said quite a bit, so I'll try to find that. There's a couple questions in one. But as far as are us being the de jure status according to international law, or are we de jure on our path? Yes, basically. Um, because as I stated earlier, we can't start off as our first move, saying that, we want decolonization to happen, and then we just first thing we do is establish the government for the Empire of Morocco without establishing individual states. That wouldn't be the case. Um, the United Nations, they can't recognize anybody, but what they can do is acknowledge the credentials of the people that say they are who whatever they say they are. So once they acknowledge the credentials of the people calling themselves a state, they notify everybody else as such, as long as everything is all the instructions have been followed to start a state, basically. Um, and
Point of
notification is
privilege.
then, yeah.
I do apologize sincerely for the interruption. Is this just a question? Is this call for state officials and political groups forming specifically, or is this an open forum?
It's an open forum. Anybody can come.
Okay, I yield.
Yeah. So but so when we talking about the United Nations, they can acknowledge the credentials, but they cannot recognize anybody. Right. Same for the WRC. So being that it's various stages of advancement, how the United Nations Charter talks about, right, that the states must pursue, right, to get to where they need to go. Um, as long as it's lawful, then it's all good. So we see this word de facto. It is, that's what I was alluding to earlier. Just because of de facto doesn't mean it's bad or mean it's not lawful. It just means that um, it's just not as it's not an unwavering principle. whereas something that de jure is more is unwavering or promising or is the substance that something de facto wish it was. De facto just means in fact. So it's a difference between facts and truth, right? Facts can change, truth doesn't change, all that type of stuff, however you want to look at it. But so de facto isn't a bad word, just like democracy is not a bad word. It doesn't mean something is, less or something like that, you know. So did that answer your question? You bro, are you still
Yes,
there?
it did. Thank you, brother. I
Okay.
appreciate it.
Okay, it's
Point of interest.
Go ahead.
Okay. I just had a question. So coming from the previous page that was just up and how he was explaining what the state is and like how you can like basically explain what the state is and to piggyback off basically what you just said, um would those points stand if you was to speak those truths? Because I mean it's a truth. That's where I'm getting it from. Would it stand if you speaking those truths in a municipality courtroom? Because you know
Yeah,
how
through
it
a state.
says
Yeah, through a
it's
state, not an individual. So just say if I know, okay, I'm a Moor. I'm a Moor. I don't know. I never met a Moroccan state, but I know I'm a Moor. I know all the U.S. codes. I know how to write my affidavit of truth. I know how to do all these things. And I go in there, right? And I say, okay, I learned this. Let me go ahead and say this. The legal effect, you won't get it because the proper person is not there saying the spell of the words. So you need the proper person that will be the state, right, to make an official appearance. You like that's a misconception a lot of Moors have. If I come and say I'm here in Siri Presume, I'm in a special appearance. The state coming on your behalf is the special appearance. So without the state, there's nothing special going on. Make sense?
true indeed. I understand that. But I guess what I'm asking is being that I know what a state is now and the paperwork says that it's a state of say North Carolina or Nevada or something like that. That's not what a state is. So being that I know that, I mean, I'm not enforcing international law, but that's just what a state is. So like, is it a state and is it proper for me to, you know, ask that type of question because like it's not a state.
Well, yeah, I mean, yeah, any question is a good question, most. I don't never feel like that, but look at it like this: only a state can stop a state. So you could be an individual and know everything you want to know, but only a state can stop a state.
Okay, I get that.
Islam.
Islam.
yeah. Um, and just a real quick build on top of that before we go into this document. Uh, it's that the France versus United States of America court case. It expresses it shares a lot of information. Um, a lot of Moors tend to think because of consular court jurisdiction being relinquished that when we talk about jurisdiction, period, that it does not relate to them and the United States having jurisdiction over them. When in fact, we talk about consular court jurisdiction, being specific, what kind of jurisdiction, even though there's many different types of consular court jurisdiction. So that was relinquished. But what else was going on? Well, jurisdiction over more subjects by the United States was still going on. But how? Because of you know not having a state. So this exactly recognition is simple. in its own way, right? You can hear recognition is irrevocable and think, hey, when you hear withdrawal of recognition and things of this nature, how is this possible? Well, it depends on what status the people who are doing the recognizing are in themselves, right? De facto, de jure, all that types of stuff, right? Um, so there is a common denominator through it all, in which Wazir Kendall said it before. State, you got to have a state. Um, Otherwise, they might not have constant court jurisdiction, all this types of stuff, but they still got jurisdiction, uh, because no state, not being a part of a state. So it's just a multifaceted thing. So we can start with this document here. I'm not sure how far we'll get with it. Obviously, we won't get through the whole thing. Um, but nonetheless, we can start reading off, and that way, come next AMPAG meeting, we can everybody will be caught up. Uh, I realized Brother Abdul started with the second document. This is the first document that they're very similar, but people can understand the build up. Um, and I'll also will try to set up another open forum sometime very soon. Um, just so as these documents are being shared and built upon, we can we can uh go in a good sequence. So this document was first. I try to have another open forum, maybe the 19th or Saturday even. And then that way Sunday, AMPAG's open forum, we can follow through, nice in the chronological order. But we'll start with this document. Um, if somebody wants to read, well, it's the United Nations General Assembly, right? 632nd meeting. The date was October 12th, 1953, right? So this is right after the 1952 case. Okay. Um, so if I can get a reader that would like to start reading point number one.
Yeah, I'll start off. I want to point out, like, y'all just pay attention how much they know. Like, they know about this situation. Mr. Zini Sarah said that many representatives could well understand the story of the occupation and the movement for the liberation of Morocco, because they had had similar phases in their own history when their people had been fighting for independence. In the Americas, people could remember the revolutions associated with the names of Washington, Bolivar, and San Martin. In Asia and Africa, many people could remember the days when they had like the Moroccan representatives today to sit as. Okay, so let me blow it back up. My phone battery. Okay, I'll pick up right there. Yeah, in Asia and Africa, many people could remember the days when they had like the Moroccan representatives today to sit as spectators while the League of Nations or the United Nations was dealing directly or indirectly with their respective causes. The colonial countries had affirmed for decades that all these Asian and African peoples had not been fit for independence, while the dominant peoples did not believe such affirmations. The Moroccan people knew, as others had knew before them, that independence had never been granted to a people, but had to be won by the force of arms. The Charter of the United Nations, however, was a means to promote an orderly evolution towards emancipation, thereby saving.
My apologies.
What's okay? Okay, yeah, the charter. Let me see. I think I got to come down. I think I started at the charter. Come down to a little down.
Start at number 3.
Okay, yeah. The Charter of the United Nations, however, was a means to promote an orderly evolution towards emancipation, thereby saving the colonized and the colonized the destruction and bloodshed attending the birth of liberty. The Assembly was today confronted with these alternatives. It would either fulfill this mission effectively in exerting such an orderly evolution, or it could choose to discuss the questions and then wrap itself in a cover of domestic jurisdiction or inaction. His delegation has chosen the first course with a view to replacing domination by free international cooperation. Let me see. Okay, with a view, yeah, to contributing abundantly as it has done in the past to the civilization and the culture of mankind. In view of the strong ties of friendship binding the French and the Syrian people, the Syrian delegation felt it is its duty towards Morocco, France, and its obligations under the Charter to contribute in an objective manner to the solution of the Moroccan question. If that attitude was understood by the French representative, the Syrian delegation would be gratified. Otherwise, it would seek satisfaction in the fact that attitudes was understood and appreciated by a sizable sector of French public opinion and by men like Mr. Mitterrand, the French cabinet minister who had resigned in protest against the policy of his government towards Morocco. Colonialism in general, and particularly France colonial policy in Morocco, was a malady which just a minute. Okay, yeah. Was malady which affected some great colonial powers. The symptoms of that malady could be detected in French bloodshed beyond the seas, in the delip the liquidation of the treasures of its creativeness and toil, and in internal uh, decisions, decisions, and internal tensions in a world already burdened with explosive problems. Mr. Zadini sincerely regretted the absence of the French delegation. He would have preferred to think that France, true to its traditions, would have invited a free discussion of the problem so as to unveil the truth. Similarly, he would not have thought that those states which had brought the Chez Lovaka question, the Iranian oil problem, the Cardinal Minzinity case, the Korean question, and many other questions to the United Nations will be using various criteria for judging the scope of the charter. Moreover, he would have liked, so I asked him to say, moreover, he would have liked to see the United Kingdom and the United States open the way in the Security Council for an investigation of the Moroccan situation in order to uh, ascertain the truth. But that method was refused because of political uh, opportunism and expediency. Surely such a policy could not gain French adherence to NATO. Moreover, the issue was not only a French Moroccan one, it was between French and 15 Asian African countries whose people had seen in the attitude of the Security Council a tendency to draw matters of national liberation and international justice into the vortex of the old war. For that reason, the people of those countries wondered about the efficiency of the United Nations and the sanctity of the charter. His delegation was disturbed that France, the United Kingdom, and some others opposed the idea of the United Nations dealing with matters concerning national movements. It was also disturbed by the attitude of the United States, which seemed to turn the United Nations into a forum for the discussion of such matters, but without the possibility of practical and tangible action, even within the limits imposed by the Charter. These delegations seem to forget that the United Nations was an organization of states which met each year to harmonize international relations, and that it was the only substitute for the battlefield. If someone wants to pick up, they can.
I'll pick up. Where are we at 10? Yes.
Yeah.
10. No one could really explain the fact that France and its supporters invoked domestic jurisdiction. Indeed, domestic jurisdiction, as the representative of the United Kingdom had implied, 630th meeting, was one of the essential provisions of the Charter. However, there were two other relevant considerations. The first was that the question as to whether a matter was one of the domestic jurisdictions or not could not be determined by an individual member state, but only by the decision of the collectivity of member states. It would be a dangerous precedent for an individual member state to disagree with the decision of the majority. The second consideration was that the question of international competence in the Moroccan case had already been settled by the Assembly itself when it had discussed and taken a decision on the question.
Point of privilege. I want to say it right fast. Like it's already settled. We're not trying to get them to agree to nothing. You just read it right there. This has already been settled. That I use.
Islam.
11. The representative of Syria recalled that the Moroccan question was over half a century old. It had been born out of the colonial policies which had led colonial powers to the path of expansion and ultimately to a world war. In the light of such experiences, the Charter had made self-determination instead of domination a prerequisite for peace. At the time when European countries had extended their domination over most of Asia and Africa, Morocco alone had remained Honorable, you need to scroll up. All right. Morocco alone had remained, sorry, go down a little bit. Go down a little bit. No. Back up to 11, right? Yeah. There we go. All right. At the time when European countries had extended their domination over most of Asia and Africa, Morocco alone had remained unsubmerged by the colonial tide. The fact had been indicative of the homogeneity of the Moroccan people, the austeriness of their foreign policies or policy, and the ability of Moroccan ambassadors in the various capitals of the world. In this connection, mention should be made of the fact that Morocco was one of the first nations to recognize United States independence after Washington had made it a realization. 12. In 1904, however, France and the United Kingdom had taken an important step towards intent cordial by agreeing that the former would introduce so-called reforms in Morocco, and that the latter would do likewise in Egypt. The course of events had made the destinies of those two Arab countries parallel. The issue of reforms had been the object of an international treaty and continued to be the central international issue of the Moroccan problem. During the growing Anglo-French harmony under the intent need to scroll up, Noble.
Let's go down.
Oh, it's yeah, down. The German Kaiser declared that Germany was also interested in introducing reforms in Morocco. As a result of the international tension thus created, the Moroccan government took the initiative to convoking an international conference, which resulted in the Act of Algeciras of 1906. The object of that treaty was twofold. First, its object was to introduce non-political reforms in Morocco on a triple basis. A, the sovereignty and independence of Morocco. B, its territorial integrity. And C, its economic independence on the basis of equality. Secondly, its object was to associate the 13 signatory powers and to replace the secret Anglo-French intent by a large community of nations. Again, the question of reforms was a central international issue, and the object of the Act of Algeciras. No one could deny that Form 1906 on those reforms were of an international character. Furthermore, the Act of Algeciras, which is a multilateral international treaty, was neither repealed nor contested. It continued to be operative and to govern the present situation. Another multilateral treaty, to which France was a party, had been signed in 1945 and at San Francisco. The Charter of the United Nations, though not dealing particularly with Morocco, influenced fundamentally the Moroccan situation by emphasizing and strengthening the sanctity of international treaties such as that of Algeciras, and by proclaiming the rights of the self-determination of peoples, the equality of nations, and international justice, and the international responsibility of member states in questions which are not essentially within their own domestic jurisdiction. Similarly, an international trend towards liberation had taken shape, thereby freeing 600 million people and putting an end to colonial imperialism. Such was the course of history, which some countries refused to accept.
Point of privilege. Do you see that language that they using right there? They
Right.
sound like they really upset. But that's what blew my mind when I found this. Like, look at the perspective. You be blindsided. Like, we feel like we sending all this stuff out to the United Nations. No one's responding. Like, really, what they think. But it's a lot of countries with us. As you keep studying, you're gonna learn, but they just ain't, within the right position to help. With that,
Can you scroll up a little bit, Honorable, so I can see all of 13? Thank you. 13. In the midst of events evolving out of the signing of the Act of Algeciras and the Charter of the United Nations, there were two events worth noting. The Treaty of Fez of 1912 with the object of introducing reforms, and the deposition of banishment of the Sultan Mohammed V in September 1953, 2 days before the opening of the session, thereby enabling France to introduce so-called reforms not contemplated either by the Act of Algeciras nor by the Treaty of Fez. Those reforms, as the representative of Pakistan had asserted 629th meeting, amounted to modifying the whole international regime in Morocco, changing its status as a sovereign but protected state to a status which made of Morocco a colony in the French Union or Empire. Thus, reforms had been the object of the Treaty of 1904, of the intervention of the German Kaiser, of the Act of Algeciras of 1906, of the Treaty of Fez of 1912, and finally, new kinds of reforms have been imposed in 1953. Those unending and self-generating reforms constituted a confusion term which had been devised to conceal a policy of expansion, dominating, and oppression. 14. It was essential to analyze the extent of mutual obligation incurred by the parties to the Treaty of Fez of 1912. A close scrutiny of that treaty would reveal the following facts. 1. The treaty had been engendered by forces. 2. The treaty, assuming that it was valid, did not extinguish Morocco as a sovereign state distinct from France. 3. The rights conferred upon France and Morocco derived from an international treaty, thereby negating the principle of French domestic jurisdiction in the case. And 4, the Treaty of Fez was only a link in the chain of international treaties related to the question. In the matter of reforms, its object and limitations were the same as those set forth in the principle of the Act of Algeciras. Moreover, the International Court of Justice, in its judgments rendered on 27 August 1952, had declared that the establishment of the French protectorate over Morocco by the Treaty of Fez did not involve any modifications of the three principles of the Act of Algeciras.
point of
Real
privilege.
quick.
What happened?
Oh, go ahead.
Go ahead. I just wanted to say what happened in August 1952. What they talking about? Anybody? France versus United States. Go ahead.
So just to backtrack to point 13, that it mentioned earlier here, I'll read a little bit over. It said, in the midst of the events evolving out of the signing of the Act of Algeciras and the Charter of the United Nations, there were two events worth noting. The Treaty of Fez of 1912 with the object of introducing reforms, and the deposition and banishment of the Sultan Mohammed V in 1953. So these two things, right? The Treaty of Fez, 1912, in which this is what were called reforms. So France was the state coming up with all the ideas as far as reforms. What should we do to help them? the Moors. So since basically what this document started off saying is that they didn't help us, and the document after that furthermore saying that they didn't help us, what happened with these reforms? Well, France took on these reforms, right? How can we tell? Well, let's study their timeline, right? Uh, those who been paying attention to how the Moroccan states plug and play certain information, you'll see that France is of high importance. Why? Because of these same reforms that they began to instill in their governments, right? So, if anybody, when we talk about plug and playing, who should we study? France. Not not everything, but there has been quite some time since um, you know, uh, 1912 and 1952 and so on and so forth. Not everything needs to be copy pasted, plug and play, but nonetheless, we can narrow down our studies. And then furthermore, it says Sultan Muhammad V was deposed of after 1952, which means that uh, it, in y'all, for those who were in AMPAG's last open forum, you all have heard that there was a letter written from the Sultan of Morocco to the President of France saying that, hey, France, I know that y'all basically instill agents to make them not trust me, right? Uh, agents in several ways. We probably won't get to what I was hoping we would reach tonight, which it speaks about religious leaders and what I believe is pronounced ulamas, ulamas, Ulemas is what that document calls it or spells it. The document that Abdul was going over. Somebody has something to say?
The point. Yeah, I was gonna say, I just want to point out real fast. Like I asked the question, I was like, what happened in 1952? And nobody really said nothing. But I just want to add to like, if you reading this information, like sometimes the date be so important. So if I know the case happened in 1952, and then right here on the page it says new kinds of reforms had been imposed in 1953, but I know some just took place in 1952 according to the case. I'm just showing you, knowing these dates, how you can understand more like what's going on, or you can just read it and say, okay, well, I know what the Act of Algeciras is, and I know what the Treaty of Fez is, and you just reading. Okay, August 1952, and you just keep reading. But what I just pointing out, the understanding of why they changed something in 1953, I wouldn't have knew that if I wouldn't have knew the case happened in 1952. So I'm just pointing out, like those dates, you can read past them, or you can know them in heart, and you can get a better understanding of the document that you're reading. I yield.
Yeah, that's another good point. Before we continue, we probably, like I said, we probably won't get to it tonight. We'll open the floor for question answer here soon. But this document, before we,
point of interest, Wazir Akil,
yeah,
is J-Bay. Just to underscore the word depose. Depose means to be removed from office. Therefore, the Moors should be cognizant of the history that France removed Muhammad V from his office of Sultan between the year 1953 and 1955. So that's what they're talking about here in 1953. What happened? Someone was deposed. Well, who was deposed? The Sultan. And he was sent to the island commonly known as Madagascar. Right. And then he was reinstated as Sultan in 1955, and shortly thereafter, France signed the Franco-Morocco agreement on March 2nd, 1956. So that's important to understand. When they say the word 1953, they're talking about the Sultan was deposed. All right? How you?
If the reader would like to continue reading, can do so.
Where we at? 14?
I thought it was 15. Is it 14?
Yes. 14. It was essential to analyze the extent of mutual obligations incurred by the parties to the Treaty of Fez of 1912. A close scrutiny of that treaty would reveal the following facts. 1. The treaty had been engendered by force. I think I already read this. You're right. So we'll move down to 15. The intervention of the United Nations in the Moroccan crisis was essential in order to bring about an orderly evolution through the process of real negotiations between Morocco and France. It was all the more necessary because the Act of Algeciras and the Treaty of Fez had no fixed time limit. Therefore, the Treaty of Fez should last only the length of time necessary to attain its objective. Those objectives comprise the inauguration of a regime in Morocco based on internal order and security, thus making it possible to introduce reforms and to ensure the economic development of Morocco. The Treaty of Fez could not be eternal and should not be kept in force if its objectives were attained, nor if France pursued a policy directly opposed to those objectives. In the latter case, the very actions of France would constitute a reason for terminating the treaty. However, should the differences arise, as in the present situation, on the interpretation and attainment of those objectives, it would become the duty of both France and Morocco to solve those differences through discussion and negotiation. But when the two parties go on.
And I just wanted to point out what it said about France. And when it was saying France constitutes what it did, like this grounds for terminating the treaty, what they did. Are you?
But when the two parties or one of them refuse to negotiate, then the United Nations should try to bring about negotiations between them and arrange a time limit. That was one of the reasons which led the 13 Arab Asian states to submit the draft resolution A-C1L16. France was undertaking actions and practicing policies in Morocco in convention to the spirit and letter of its treaty obligations. The first important step in French policy in Morocco was pacification and a policy of occupation and direct rule. In that connection, it should be recalled that when the French forces had in 1912 imposed on the Sultan the Treaty of Fez, it did not mean that the Moroccan people had acquiesced in the policy of occupation. Actually, fighting had continued almost uninterruptedly for 23 years, obliging France to use several army divisions, as it did in 1926. Moreover, the fact that the Moroccan people had never acquiesced in French rule had been conceded by General Gula, I can't pronounce his name. Assistance here?
I don't even see where you are, to be honest. Oh, 16?
Yes. So moreover, the fact that the Moroccan people had never acquiesced in French rule had been conceded by General
Gilami.
Gilami, okay. The present French resident general in Morocco. The Moroccan people would not accept a political order unless it had a strong moral basis. That complex of nationhood and moral belief was the indication of a dynamic and dangerous factor in the present situation. Moreover, France should not have the illusion that Morocco was now curbed into final submission. If, as France had asserted, Morocco was completely pacified, then what was the need of an ever increasing policy and military force of measures equivalent to martial law, which had been there for 40 years, of the suppression of all liberties and the building of fortifications throughout Morocco? Was it on account of communism, a term so dear to the Americans? There was no communism in the Moroccan movement. The obvious reason was that incidents were happening daily, so that goals were filled with thousands of Moroccans. Even the Sultan had lately been banished. In view of the gravity of the situation, it was ridiculous to hear some representatives imply that the discussions in the United Nations might incite the Moroccan population to disorderly actions. If someone would like to read, you can read, or I can continue.
Yeah, what you on, 17?
Yes.
Yeah, I'll continue. Stroll up a little bit for me, President.
Islam.
The French forces in Morocco were not soldiers of the free world helping to maintain the policy of collective security in case of a world conflict. They were forces designed to help protect France's interests in Morocco from the Moroccans. Moreover, the French civil and military controllers constituted the real authority in Morocco. Their command was upheld by the French army everywhere. They were organized in a hierarchy up to the resident general, who, after the last reforms, would not be leaving any possibility of action to the Moroccan throne, nor to the central Moroccan governments in their own home affairs. The present regime or direct rule in Morocco was not only contrary to the Treaty of Fez, but it prevented the country from developing the political machinery necessary for the self-government mentioned in the United Nations Charter as the ultimate objective for dependent territory. And I just want to point out, like, everything that we're doing is what what they're saying they didn't have. They didn't have this whole system set up, what we're putting together. Number 18, another example was the overburdening of the Moroccan budget by the cost of the double administration, a Moroccan one, which was only for show, and the real French one. Since the salaries of the French officials constituted the great part of the budget, the Moroccan taxpayers were supporting an administrative setup bent up, administrative setup bent upon a policy of uh, denomination. Thus, the Moroccan people saw their budget drained to such an extent that there was no possibility of constructive measures of an economic, social, or cultural nature. What title remained was used to support constructive measures intended to serve the French settlers. That policy of direct rule, lavish spending, and so-called pacification might have enriched Morocco, but it had surely reduced to poverty the Moroccan people. 19. French policy in Morocco was also leading to the disruption of Moroccan unity and the undermining of its existence as a nation and of its Arab culture. 20. Moroccan national.
My apologies, did it again. Hold on.
We're on 20. Okay, 20. Moroccan national unity had been in existence from the ninth century until the advent of French rule in the 19th century. Indeed, French national unity and that of many other countries was much more recent and of less solid substance than that of Morocco. When the Arabs had migrated to Morocco in the 7th and 8th century, they had blended with the Berbers and other races in Morocco, thereby forming one nation. That unity was due to two main factors. First, the intermingling from the beginning of Arabs and non-Arabs and their adoption of a common language, culture, and law. And secondly, the possession of a common heritage, 13 centuries old. Thus, today, Arabs and Berbers were, and I just want to point out, Berbers, though those are darker skinned Moors, Berbers were particularly indistinguishable, except in some isolated local localities. But I want to point out there just the distinction when they like, okay, we're talking about Moors or Moroccans, but for the most part, when you think about an Arab or Moroccan, you think about the Middle East, so you really don't get the distinction. But you finna trying to get the distinction of Arab Moors and then the Moors.
Yeah, I
So
had
they just
on the
said
answer.
they go ahead. Are you?
Yeah, just for I guess they're trying to just make this because we already know Arabs is Arabs. Is when they say Berbers, I guess they're talking about us in the sense the the quote unquote blacks who don't know they're Moroccans, the true Moroccans. So yeah, I was just trying to just make sure that when they talk about Berbers, they basically just talking about us in a sense, and I yield that.
Point of interest, ARC, the beginning of 20th said Moroccan national unity had been in existence from the 9th century until the advert of French rule. Um, advert was in a season observed in most Christian denominations as a time of expecting, waiting, or preparation for both the celebration of the nativity of Christ of Christmas and return of Christ. So they're separating right then and there, where there was at the beginning of Christianity, where they're pretty much plain rule, or I think John IV the Pope put, warheads are saying people, Moors or Moroccans, should be or with them or be enslaved with them too. I think they trying to. If I'm not mistaken on that. Yeah.
Okay. Thus,
Real
today,
real quick point of interest. Just to answer the brother's question. Um, Pretty much as it relates to the first sentence, the Moroccan national it says Moroccan national unity had been in existence from the 19th century. So we're talking about the 1800s until the advent of French rule in the 19th century.
Right.
So this has direct correlation to the Treaty of Madrid. And especially from that point on, and that time it was really crunch time for the Moors because from 1880, really before that point, but 1880 from 1906, 1912, you obviously got France trying to solidify their position. And you got obviously have Morocco trying to solidify its position as an independent state that whole time, in which it did. So the Moroccan nationals, 1880 treaty, Article 15, right? You claim your nationality as long as you choose the Moroccan state. You could be a Moroccan national, right? Um, so that's in regards to that question. But I also want to call out what you all have called out already is that the difference between the Arabs and the Berbers and the combination of their worlds, right? The nations or the states, or making it one state, is also important to note that when we're talking about the reforms, um, you can see today that United or the France, in one of the ways, let's just say administrative reforms, right? That's the first thing we're supposed to focus on, administrative reforms. So obviously France would focus on that. What the question is, what has France done since 1912 or even 1952, if you want to say, or depending on how you want to look at it. You can see that some of their ways are implemented in our Constitution. I mean, our Constitution comes from France. So when we talk about how they tried to uh, set up their administrative reforms in their own state, how they tried to decentralize a lot of how they tried to decentralize their territory. And then you see our Constitution for the Empire of Morocco deals with a decentralized government. Then you start to connect the dots, and narrow down your studies as to why a decentralized opposed to centralized and things of that nature. But I yield. I heard somebody want to say something.
Oh, it was Kanil Ali. Thank you for that, brother. I do appreciate that explanation, clearing that up for me. I'm with my study, so I'm trying to get the clear picture. But I do thank you for that. With that, I yield.
So we can continue on with 21, and we'll conclude. We'll read for another 5 minutes. Then we'll open up question and answer and conclude with that. So if the reader would like to continue with the rest of 20.
Is even the notorious El Gladu was himself of Arab Berber descent. That was also true of the Sultan and of millions of people. Indeed, there was more like-mindedness among the Moroccan people in their thinking, habits, religion, history, customs, language, and other aspects of their life than in most other countries. 21. To judge from French policy in the last 4 decades, it would appear that France was faced with the choice either of replacing its colonial policy by one of free international cooperation or seeking to undermine the existence of Moroccans as a nation, its unity and culture in order to ensure the denomination through the choice, though the choice was a hard one. France had restored to a policy which today proved to be wrong, inexpedient, and impractical. Mr. Zudin wished to discuss that policy and thereby explain some points of the draft resolution, AC 1L60. 22. On 11 September 1914, Morocco was adversely divided into so-called Arab and Berber regions in order to encourage local tendencies as opposed to the common life of the nation. Moreover, the Berber areas had to be de-Islam and return to the practice of pre-Islamic customs. That policy had continued for about 15 years, but had not been adequate to break the unity of the Moroccan people. Accordingly, the notorious Berber Dahir had been proclaimed in 1930 in accordance with the decree. The Berber population had been removed from Islamic jurisdiction, and French had begun to establish purely Berber schools in which no Arabic was taught, though no general Berber language had ever existed before. Moreover, though the Berbers were Muslims, Islamic education was forbidden in almost all Berber schools, which were taught mainly in France. The real reason behind the Berbers' decree was not the furthering of Berber interests, but of French interests. Moreover, French educational policy in Morocco had been aimed at artificially isolating the Berber population and bringing them closer to the French traditions and language. The interpretation had been supported by Professor uh, Godfrey uh, de Montbains, an educational consultant to the French authorities in North Africa. Furthermore, it was significant that the so-called Berber regions were offering uh, so-called Berber regions, gold or exile was relatively greater than those from so-called non-Berber regions. Finally, it was interesting to note that why military operations had to be undertaken a few weeks ago concerning Bina, Sanchez, and Tad- Tadela of the so-called Berber regions. I'm gonna read 23 and I'm gonna stop 23. Another attempt to divide the country had been made by the creation of three types of regions, namely civil, military, and forbidden regions, thereby restricting the free circulation of the Moroccan people.
All
I
right,
yield.
so we'll stop there. But before we open up for question and answer, I just want to bring one more point to the floor, which speaks on in 22, Islamized and return to the practice of pre-Islamic customs. Um, in which that well, let's just read this whole thing right quick. It says on September 11th, 1914, Morocco was arbitrarily divided into so-called Arab and Berber regions in order to encourage local tendencies as opposed to the common life of the nation. Moreover, the Berber areas had to be de-Islamized, and return to the practice of pre-Islamic customs. It says that policy had continued for about 15 years, but had not been adequate to break the unity of Moroccan people. So this was, and we'll go over this website soon, talking about this policy and other policies, but in the intent of them. But what I wanted to call out here was during this time frame, right, the 1930s. We can say that this is obviously after Noble Drew Ali died. But when did the Treaty of Fez come into play? 1912. Okay, when did the Moorish Science Temple of America come into play? 1913. Okay, so when we read that France had influenced groups to help get the Sultan out of the position he was in, right, with the encouragement of his own people to get him out of there somehow, some way. We also have what? This reminder. This is also relates to the other document that Abdul Bey of Ampag was talking about in this open forum, when the Sultan wrote the letter to the president saying, "Hey, basically, I know you got agents out there. You instill agents to try to get me out of office as the Sultan." So if the Treaty of Fez in 1912, Moorish Science Temple America 1913, and we talk about these, I believe it's called Alumas, Ulemas, or Ulmas, these religious leaders that had a play in this. Well, what religious leaders we're talking about? We're talking about religious leaders that dealt with the Islamized practices, right? Trying to separate Arab and Berber, right? So this early 1900 time frame was really, really, really COINTELPRO, because you got different stages of it. COINTELPRO before COINTELPRO. Because what we have here is basically Arab world being introduced to say, hey, these are the true Moors. On top of these who are called Ulumas or Umas, these religious leaders, right, who are assisting with this. So they're assisting the colonizer. What you want to look at is France and the United States. Matters none, but they're assisting in the deposing of the Sultan by promoting the opposite of what's supposed to be promoted. So that's another thing to look to take from. We didn't get into it too much tonight. It kind of speaks on it in 25 a little bit, but I just want to call this out that we if we pay attention to the simple words, what does Oma mean? What does recognition mean? The simple words, we can see where COINTELPRO resides, where they at in all of this. Because obviously, if we see Morocco was arbitrarily divided. It was arbitrarily divided, meaning that this wasn't something that we agreed on. We didn't shook hands for this to happen. It was arbitrarily divided into so-called Arab and Berber. And for those who seen my post, I posted probably about 2 weeks ago or so about how France they also were a big part as to why the world believes that Arabic is our most primal and original language, and all of that. That was a part of their mindset that they wanted to instill. So once we take all of this stuff into account, we basically see that there's a lot that we have to remember or reorganize, right? Remember, in order to see this unwavering principle through. All right, so I just want to call out those few things: the separation between the Arabs and the Berbers being arbitrarily divided into that such a thing, as well as these agents and umas or these religious leaders that are being encouraged by the colonizers. So when we talk about why we need to speak on Moorish Americans and all this type of stuff, well, we got to speak on the exact problem, right? We got to don't just clean the spider web. We got to kill the spider. right? What is the problem? Right? How do we make this an umbrella? So, or an umbrella effect, if you will. So, I just wanted to call that out, you know, the treaty 1912, 1913, Moorish Science Temple of America. And in this document, you see that France instilled agents, instilled Ummahs, religious leaders, because certain people couldn't do certain things on certain spheres of reality, especially being at a certain time, right? You got domestic law, in which, just like the United States did, they say, hey, we're going to do this for the Moors. As soon as they get on the president's desk, it sits there for the next 10, 20, 30, 70 years. Because when it comes to this domestic situation, then, you know, these religious leaders, these organizations and whatnot, you know, it starts to change. Right. So I just wanted to speak on that a little bit, but we can open up the floor for questions and answer. If nobody else has a point of interest, well, regardless, we can open up the floor for questions and answers. So I'll yield to that.
Islam, brother Akil. This is Brother Yahya here at New Al Andalusia. You're so on point with that number 22. But what I'd like to point out or say about that is that what I recognize is that unity is the greatest weapon that we have, and it's their greatest fear. And the way they attack that, it's as we say, it's copy and paste, plug and play. They run that same play, whether it's in, you know, on the continent of Africa or all the way over here. It's the same play, divide and conquer. They and that word you're talking about, ulamas or the ulamas, the religious leaders, they're just subject to be bought off like anybody else. You know, you give them a pretty house, a nice car, a big salary. Yeah, they'll do your biddings and they'll make religious edicts and religious statements and make your people seem like they're out of line and you know, disrupt your whole movement. So with the unity of the people, the grassroots people, with the unity of those people, nothing can stop us, even with religious leaders, those other groups that want to take things in another direction or not move in any direction or block our movement. I think it was J. Edgar Hoover said his greatest fear, or one of the greatest threats to the United States, was the um, unity or Black liberation or unity for Black liberation. But the idea is we must remain unified and pressing forward to our goal, no matter what. Now, yeah, we're going to have differences, as my brother Kurt Palmer Bay says. Yes, we're going to disagree, but we don't have to be disagreeable. If we can agree on that, then we can move forward and reach our goal. And with that, I yield.
Islam. Good points. Anybody else have any comments or questions to bring to the table before we close out here?
And I want to add nothing to say before you close. I just want to thank everybody for coming. I enjoyed it. It's long.
Islam. All right, so we'll close out. Just like Wazir Kenneth said, I too appreciate everybody coming. We'll actually have
Islam.
another. Somebody got a question? Comment? Okay, you know, Islam means 10,000 different things, so I don't know if anybody is saying point of interest when they say that or not, but So we'll close out here. We'll have another open forum here in the next few days. So I'll keep everybody notified the same way they were notified these past few days. So just be on the lookout for that. But again, I appreciate you all for coming. Peace and love to you all. Hope to see you all next time. Islam.
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 Islam, everyone.
Peace. It's
Peace and love.